Good evening. This is Laws 19038, Planning and Environment Law. This is week number 5 in the course, but today we'll be covering week 4 material and probably be lucky to get through that material. There is, this week, as always, a lot of reading material. Thank you for bearing with us. I hope that you're doing your reading and trying your best to understand the material. I'd like to cover Bates chapter 9, but first I'd like to deal with England, chapters 4 and 6. So you're welcome to follow the commentary as we proceed. I'll be starting from page 85, which is the beginning of chapter 4. The heading, Local Planning Instruments and Planning Partnerships. This runs through from page 85 through to page 130, and it's under the general heading of Urban Planning Administration and Management. Now earlier, and in particular in chapter 3 of England, we looked at state planning instruments provided for under the Act, which set out the high order strategic imperatives for planning law in Queensland. It remains essentially the task of local governments, says England, to translate these high order strategic imperatives into locally specific strategies, policies and assessment criteria for use day to day. So therefore, while the state planning instruments set the overarching strategic framework, local planning instruments and partnerships tend to have the greatest bearing on what happens on the ground. So that's what we'll be covering tonight. I'll leave you to read the historical background, which is 86 through to 88, and provide some commentary in relation to the Integrated Planning Act reforms of 1997, which commence at page 88 in England. One of the fundamental goals of the Integrated Planning Act was to make the shift away from prescriptive planning documents towards more flexible performance-based planning instruments. And under the Integrated Planning Act, planning instruments were to become focused on the achievement of specified planning outcomes. Those of you that practiced in the area or had some familiarity with the area prior to 1997 will recall extensive tables of zoning which indicated what might be obtained with consent, what might be prohibited, etc. And as England describes it, that was very prescriptive by way of a document. Now we're looking more in terms of generating planning policies and planning outcomes rather than being very prescriptive in that sense. Now this is an important point. Dot point 1 on page 88, England says decision makers were not to view statements of desired objectives as view statements of desired objectives as merely another form of discretionary guidance, as was typically the case with planning policies before the IPA. So under the IPA, achieving desired outcomes is actually the reason of planning. England goes on to talk about the prohibition on prohibitions, which was introduced in the Integrated Planning Act. And you might be aware that with the introduction of the Sustainable Planning Act, that prohibition on prohibitions has been overturned. So it's been reintroduced. It's regarded by some as one of the negative aspects of Sustainable Planning Act compared to the Integrated Planning Act. I don't share that view. Now I'll take you through to, so that really takes us through the history until we get to the law as it is now, which is the Sustainable Planning Act, and in particular from page 94 onwards. Local planning schemes. A local government may make local planning schemes to provide for an integrated planning policy for its territory, and that enables a local government to undertake development in a strategic way. Local governments are not obliged to prepare planning schemes, but if they do, they must review them every 10 years. Now, at 94, at the bottom of that first page, England describes the form and content of a local planning scheme. And you'll see the list of things that they must have, and headline act in that regard is that the local planning scheme must identify strategic outcomes for the planning scheme area. So that's first and foremost. And then include measures to facilitate achieving those strategic outcomes. And it becomes then more concerned with mechanics after that. But the highlight there is the strategic nature of local planning schemes. So on page 95, England talks about the key terms explained in the body of the Act are core matters, state and regional dimensions, and measures facilitating the achievement of strategic outcomes. The Act summarises the minimum content required for plans in sections 88 and 89, so you can have a look at that in more detail if you wish. But all new and revised planning schemes made under the Act will also have to comply with the standard planning scheme provisions, section 55, and they state the additional content and structure requirements, which is outlined further in the commentary. All right, now the Queensland planning provisions, there is Module A, which contains the mandatory text, and Module B, which provides instructions and further guidance about drafting local planning schemes and includes various suites of standardised zones and definitions. So local governments may select those standardised schemes through Module B if they wish, bearing in mind the mandatory provisions of Module A. On page 96, England goes on to describe the fact that planning policies, or planning provisions rather, made under the Act need to take on a certain format. And you'll see there the list of parts 1 to 10 and the various schedules and appendices. And you'll note that parts 6 through to 9 inclusive are mostly comprised of various codes. So you've got the strategic framework, followed by the infrastructure plan, the table of assessments, and then a number of codes. Let's have a look at part 3, which is strategic framework, and the planning provisions require all local governments to include strategic framework in the planning schemes, and that is then dictating the structure of the strategic framework. And there's a number of things that need to be stated there. Part 5 deals with tables of assessment, and you'll see that Part 5 and Schedule 2 of the Act identify the level of assessment and the assessment criteria necessary for development within the planning scheme area. I'll just draw your attention to point number 3 in that heading of tables of assessment. It's on page 98 of England, where she says, having identified the type of use and the applicable zone, we're then to refer to the table of assessment for the applicable zone or overlay to identify the level of assessment and any applicable codes applying to that proposed use in the area. So the example there is in box 4.1, which happens to be the level of assessment table for green space conservation areas in Brisbane. And that provides more detail to the commentary that England is providing. Now, I mentioned that parts 6 through 9 inclusive are mostly comprising of codes, and England goes on to describe those codes from pages 99 onwards, and you'll see that codes comprise the bulk of the material, and they're designed to apply in defined areas or maybe stated as being for specific types of developments. Zones, each zone code will state a purpose for the zone and the overall outcomes that will achieve that purpose, and a code may identify more specific performance outcome and acceptable outcomes. And as mentioned in Module B, there are a standard suite of zones that can be used. Now, local plans go one step further beyond zones and provide more detailed planning than zones. So we're going from the overall strategic progressively down to the more and more specific details, but always bearing in mind that the overall effect that we're trying to achieve is stated strategically, and that is what needs to be worked towards. So when I say more detail, I don't necessarily mean more prescriptive in the old sense. Okay, I'd just like to comment about making, amending or repealing planning schemes. That's on page 105 onwards, and England makes the point that the process of making or amending a planning scheme is stated in a statutory guideline, and there are 5 stages, and she outlines those at the bottom of page 105. Just at the bottom of page 106, she says, if after public consultation a change makes the proposed planning scheme significantly different from the version previously released for public consultation, then the public must be consulted again, at least about the change, and the question of what constitutes a significant difference, therefore requiring a change to be the subject of public consultation again, was considered in Clark and Cookshire Council, 2000 decision from Queensland Planning and Environment Court, 123, and that decision is outlined in the box there. All right, so what we've covered so far are those documents, those instruments, if you like, which relate to zoning schemes generally at the lower level than the highly strategic state level schemes which were dealt with in chapter 3. But in addition to the ones that we've outlined, there are some other local planning instruments. They're outlined from page 109 onwards. England identifies 2 others, and they serve more limited purposes, and they're temporary local planning instruments and planning scheme policies. Temporary is the first one she comments on at page 110, where she says that that's an instrument made by a local government to protect a planning scheme area from adverse impacts. A local government may only make a temporary local planning instrument if the minister is satisfied that there is significant risk of environmental harm and the delay involved in amending the planning scheme would increase the risk. 2 points there. You'll note that when a temporary local planning instrument comes into effect, firstly, it's made as a result of a decision by the minister, and secondly, it's done in circumstances where there's a perceived risk to the environment. So in adopting that, we're really adopting in many ways a legislative form of the precautionary principle that we've talked about before. I know we're moving fairly quickly, but there is a lot of reading, and I trust that by the time you're listening to me through this commentary, you would have, or certainly should have, read the material for yourself. What I'm doing is I'm identifying what I think are the main important parts. You may disagree. You may stress other areas of the material. So it's really my guide to what England is saying with my additional comments. I'd like to continue at page 113, which deals with state powers in relation to local planning instruments. The state government is responsible for a number of planning instruments, regional planning regulatory instruments, plans, state planning policies, and standard planning scheme provisions. Excuse me one sec. The state government also holds a number of powers allowing it to contribute to or modify the operation of local planning instruments. And the purpose of the State Interest Review is to ensure that an integrated whole-of-government approach to the supply of infrastructure and development is consistent with local counterparts. There are some ministerial directions which are referred to, where the minister may direct a local government to take action, but only if it's satisfied, or he or she is satisfied that it's necessary to protect or give effect to a state interest. I'll just move now to page 115 in the commentary, which deals with existing uses, superseded planning schemes, and compensation matters. Firstly, existing uses. Any existing use or approved development that was lawful before a new planning instrument is made, remains lawful afterwards, and despite anything contained in the new planning instrument. If an existing use has been abandoned, which is at the bottom of the page, then the re-establishment of that use will amount to a new use and that then requires a development approval. So the question obviously comes into play, what is a deemed abandonment in this context? The case, which is referred to as KT Corporation against Queensland Government, Main Roads and the local Logan City Council, where a sign on the highway had been removed in 2001. The corporation applied to have it re-erected. Main Road said no, in their capacity as a concurrence referral agency, and the application was therefore refused. But in the Planning and Environment Court, Judge Wilson, as he was then in 2003, held that despite the long delay, an intention to resume use of the site had always remained, and so therefore there was no abandonment of the use. So the intention of the occupier of the property was held by His Honour to be highly relevant. Now contrast that to the 2006 decision of Bentar and BCC, where in that case the court found that abandonment had occurred. The next topic is on 118 and deals with development superseded planning scheme applications. Comments are made as follows. Planning legislation in Queensland takes the unusual path of making compensation available to owners of existing interest in land if the development potential of their interest is adversely affected by changes to a planning scheme or policy. So that's not a change in the actual use as it was maintained by the owner at the time that the planning when the planning laws changed, but it was really talking about if there's a change in the development potential. And in order to claim compensation for this injurious affection, the owner must first make a development application requesting the manager assess and decide the application under the old planning scheme. So that seems a very theoretical approach, but I mean, that's the way it's to be done. And then reasonable compensation is the difference between the market value immediately before the change came into effect and the market value immediately after the change came into effect. All right, now I'll just ask if there's any questions at this stage.
Oh, I don't have any questions at the moment, John. Thank you.
Okay, thank you. If I can move on to planning partnerships. This is at page 120, and in that there's a commentary of the way partnerships can be brought into effect to essentially provide for a better use of the integrated land, better use of the way in which land is used, and a structural plan, which is referred to at 121, is an integrated land use plan setting out the broad environmental, infrastructure and development intent to guide detailed planning for the area. Over the page, while a structural plan is being prepared, special measures operate to prevent potentially incompatible development, and any other development must be made subject to the prior approval of a master plan. All right, so master plans are then referred to, page 122, and a master plan provides additional detail consistent with the structure plan for an individual master plan unit within the master planned area. And master plans will normally be prepared by applicant developers. So once approved, the master plan attaches to all land in the master planning unit. It's binding on all owners and occupiers of the land and is immune from variation by subsequent planning instruments. So what we're really talking about there is a process where developers, in conjunction with planning authorities, work cooperatively to provide a strategic approach for development of a particular area of land, relatively large tracts of land, and that assists in terms of providing developers with a much better focus, a much more strategic focus, and ideally for the consumers, ultimately a cheaper product as a result of having incorporated so many steps in that one major strategic step. I'll just draw you to the conclusion then of the chapter at page 128, where England says, 3/4 of the way down the page, in order to fix up some of the problems generated by the ambitious nature of the Integrated Planning Act reform package, the Sustainable Planning Act has, in some ways, taken a step backwards. It reintroduced the concept of prohibited development. I don't see that as a step back, but it might be seen as. And it reaffirmed the importance of individually tailored strategic framework for every planning scheme. So in that sense, it has become a little more prescriptive than was the ideological approach adopted in many ways by the Integrated Planning Act. All right, well, that concludes what I wish to say about Chapter 4 of England. So I'd like to move on now to Chapter 6 of England, which deals with the matter of approvals and conditions and charges, ABC. Pages 188 through to 219 inclusive. The Act, says England, creates 4 types of approval. Preliminary approval and development permits, which are really development approvals, compliance permits, and compliance certificates. So they're the 4 types of approvals which are created by the Act. And in this chapter, England describes those different types of approvals and examines the nature of the development conditions and describes the test for reasonableness or relevance, which applies to all development conditions as considered by the courts. So the first part of those 3 main areas covered by this chapter is approvals. And that's part A. That'll take us from page 188 through to page 200. As mentioned, there are 2 kinds of development approvals. There is the preliminary approval and the development permit. And they are, of course, 2 of the 4 types of approvals created by the Sustainable Planning Act. A preliminary approval provides or approves accessible development to the extent stated in the approval, and a development permit authorises accessible development to actually take place. So that's pretty logical. The preliminary approval gives approval to an extent, but the development permit allows the matter to actually proceed. On page 190, there's commentary in relation to what happens if a development approval is changed. And then at 191, if there are changes under another act or cancellations. If a responsible entity, for example a concurrence agency, has jurisdiction to change or cancel a development condition under another act, maybe the Environmental Planning Act, then the provisions of the other act prevail to the extent of any inconsistency. Just over the page, there's provisions there about extending a development permit. All right, so the first 2 types of approvals under the Act are development approvals preliminary and development approvals development permits. The 3rd and 4th type of approvals, which are created by the Act, are compliance permits and compliance certificates. And you'll see the commentary there from page 192, where England says that the compliance stage of IDAS, Integrated Development Assessment Scheme, enables development documents or works relating to development to be assessed for compliance against an applicable regulation, instrument, approval, or compliance permit. If the development falls within Schedule 18, it no longer requires a development permit, only a compliance permit. And a compliance certificate approves documents or works. A compliance permit, on the other hand, actually authorises development. So a little bit like the difference between the preliminary approval and the development permit that we talked about before. Deemed approvals. Unlike the Integrated Planning Act, the current Act allows particular types of code-assessable development applications to become deemed approval should the assessment manager fail to make a decision within the applicable timeframe, and we talked about that previously. On to page 195, there's commentary there about section 242 and preliminary approvals in operations. They're heading flexibility versus accountability. Now, preliminary approvals allow applicants to stage their development application in line with the project's other progress. Developers will often be reluctant to invest large sums of money in detailed project design in the absence of an initial indication of support from assessment managers, and that makes a lot of sense. Over the page at 196, England says, because they seek to vary the effect of a local planning instrument, preliminary approval applications must be publicly notified. Well, that makes sense. However, once a preliminary approval has been given, any further public notification requirements for the remainder of the project are extinguished. So the combined effect of those two statements, which are separate sections under the Act, is that developers who apply for a preliminary approval may obtain significant benefits in terms of time and economy of scale and, if you like, the ability to deal with objections much early on in the process, leaving them free and confident to proceed with the balance of the process. So in practical terms, there are important provisions to get your head around if you're working in the area. Applications for a 242 preliminary approval follow the normal IDAS procedure for assessable development, subject to a number of variations, which are outlined in pages 196 to 197. I'll move across to page 198. Are there, says England, or should there be any other limitations on the flexibility and cost effectiveness offered by preliminary approvals? The questions arose in Fox against the Brisbane City Council. And in that case, in declaratory proceedings before the Planning and Environment Court, a number of issues were raised, including whether the applications were piecemeal and in breach of the pioneer principle. Now, I'm just going to stop you there and just explain a couple of things. When we talk about declaratory proceedings, we're talking about a proceeding where the applicant seeks a declaration. A declaration is a statement by the court as to what is the law, what is the legal position in the particular case before it. It's not technically providing a legal remedy other than, except that it's providing a statement of what the law is, leaving the parties effectively to draw their own conclusions as to how it operates in their particular case. So that's a declaration. It's called an equitable remedy. And the second thing is the pioneer principle. That requires applicants to reveal the whole of their intended development, including all of the intended uses and total land area affected, in appropriate detail in a development application. Now, in that case of Fox against Brisbane City Council, His Honour Judge Brabazon held that even though the application for Stage 1 land only involved operational work, that operational work was, as a matter of fact and degree, part of a material change of use application to convert land into an industrial estate. And as a result, His Honour reasoned that there are a number of steps to be followed. Number one, even though there are two separate applications, the operational work would cut across both stages 1 and 2 land. Therefore, all the land was to be cut and levelled with the earth moved. Number two, it's possible for the operational work to also amount to a material change of use. Number three, the operational work could be classed as building work And number 4, as an application for stage 1 had not undergone impact assessment, council had been deprived of the potential of public submissions and submitters were denied the right of appeal. Now, the Court of Appeal affirmed the decision of Judge Brabazon, but His Honour the Chief Justice de Jersey, did dissent in that particular judgment and held that there was no breach of the pioneer principle. One will always consider the opinion of the Chief Justice and give certain weight to it, even if in the odd occasion, or even wherein the odd occasion the Chief Justice is in the minority. Now that's part A of this chapter, which deals with the topic of approvals. I'd now like to move on to part B of chapter 6, which deals with conditions. And conditions start at page 200 and go through to page 210. The Act allows assessment managers to give development approvals subject to conditions, and decision makers are not, in this respect, unlimited in their power. They need to forge a balance, says England, between competing public and private interests in planning, and that's nowhere better demonstrated than in the setting of conditions. Now, England goes on to describe the general requirements, where Chapter 6, Division 6 contains some specific requirements for all conditions imposed in approvals, and Section 346 states that some of the matters where conditions may legitimately contain information. For example, conditions may place a limit on how long a lawful use may continue, or may require compliance with an infrastructure agreement, or require payment of security to report or to support the condition. I'm going to stop on that first one, where a local government, as I recall in New South Wales, around the Byron Bay area, did provide an approval in relation to a housing development, but put on a strict limit that it was only for a relatively short period of time, as I recall, somewhere in the order of 20 years or so, at which time that approval would lapse and presumably the house would have to have been destroyed or otherwise made the subject of a fresh application to continue to be habitable home. Now, Section 347 prohibits certain conditions and lists those. So you've got some where conditions can be implemented, and that's 346, and 347 where conditions cannot be implemented. 348 allows for the making of agreements about those conditions, including their implementation, but it goes on to say that all conditions must be relevant to or be reasonably required in respect of the development. So it is one or either. You might think it should be both relevant and reasonably required, but the law says the condition would be lawful if it is relevant or it is reasonably required. Now, in the commentary, England goes on to initially describe the second of those two things, which is what is a reasonably required condition, and that's pages 202 to 206. And then she deals with the first of those two issues later, which is what is a relevant but not unreasonable condition, from 206 onwards. So let's go back to discuss what is a reasonably required condition. This is the second limb, and it reflects long-established common law principles. In order to be legally valid, planning conditions must fairly and reasonably relate to the development. The requirement of a fair and reasonable condition was spelt out in Newbury against the Secretary of State for the Environment, and for planning purposes it was determined that the test has three distinct requirements. Number one, the conditions must be for a planning purpose and not for any ulterior purpose. Second dot point on 203, A condition is imposed for proper planning purpose if it is imposed in good faith and not with a view to achieving ends or objects extraneous to the purpose for which the discretion exists. Number 2, conditions must fairly and reasonably relate to the development permitted. It requires a condition to be clearly necessitated by the actual impact of the particular development. And there's a case there of building owners against Sydney City Council. And number 3, the third of the three, is conditions must not be so unreasonable that no reasonable planning authority could have imposed them. So discretionary powers should be exercised in good faith. The Newbury test that we've been describing has been regularly applied in Australian courts. There are some other grounds of invalidity. They're mentioned on page 204. Lack of certainty, lack of finality, unenforceable conditions, unnecessary conditions, conditions should not change the fundamental nature of the application, and must not prohibit future development applications. So there are other grounds upon which conditions might be regarded or held to be invalid. Have a look at the example in box 6.1, where the integration of referral agencies' licensing powers into development approvals under IDAS makes their conditions subject to the same test of reasonableness or relevance as other conditions in development approvals. And there's reference there to the case of McBain against Cliftonshire Council, 1995, where the local government gave planning permission for a piggery that was going to be undertaken in staged increments, and each incremental increase could only take place according to the condition with the written approval of the local government, if advised that the increase would be environmentally sustainable. The Court of Appeal didn't like that condition and said it offended the finality principle. So you'll see on page 204 these other bases upon which a court might strike out a condition, and the second one is lack of finality. The courts don't like a condition that has indefinite operation. However, if we look at page 206, we'll see a different set of examples. And the first one is Bardell against the Council of the Shire of Isis, where the applicant successfully appealed a condition requiring the applicant to clean and dispose of any fish kills in the man-made lake. Judge Scone held that that condition was too remote to justify imposing the condition on the applicant. So that decision went with the applicant. The one that it does contrast is Whale Waste against Maroochydore Council, where a referral agency condition requiring the applicant to reapply annually was upheld, and a condition requiring annual reapplication was, in the circumstances, relevant, held the court, despite the lack of certainty that it created. Now, one of the problems, of course, in studying law is that every word, every case is open to interpretation, and it's open to being distinguished by a different court. So where you have different judges of the Planning and Environment Court taking different views of circumstances in different cases, it leads to some degree of uncertainty, particularly if you're an advisor trying to give some definitive advice to a client faced with those same circumstances. But that is, I'm afraid, the nature of law, and the reason why lawyers will often seem to have two hands when they talk about, on the other hand, this may occur. Or maybe three hands if they go on and make further qualifications, is what I really mean to say. Now, England talked about the second of those conditions, that is the reasonable requirement condition, at 202. Now at 206 she talks about what is relevant but not unreasonable. And the case that she refers to is Lloyd and Robinson. It's an old case, 62, where an approval condition required the applicant to transfer 25 acres of land to the Crown free of cost. The decision was upheld because, though not specified in the legislation, the Commission held the court could impose any condition that was bona fide and within the limits indicated by the nature of the purposes for which the Commission was entrusted with the relevant discretion. Those principles were reviewed and approved in the Timwood Holdings case 2004, where a condition in the subdivision approval requiring a portion of a larger area be vested in the Crown free of cost and without payment of compensation was also upheld. So the comment is made at the bottom of 207 that from these cases it would appear when applying the test of relevance as stated in 345 of the Act, courts in Queensland will strike out conditions that, and over the page, 1, do not relate to an imminent development. 2, do not relate to the specific development. 3, are not sufficiently important to the integrity of the planning scheme. Or 4, present a conflict with competing planning considerations. In planning and environment law, the law needs to balance the interests of the public generally against the interest of the private owner. And some comments in that regard are made in 208 through to 210. England says, from an applicant's point of view, conditions are an imposition that restricts their freedom to develop what is usually their own land at a cost that suits their budget. There's reference then to summerland plantations, where to use the plans of the Department of Transport for road purposes at some unspecified time in the future as justification for a substantial restriction with no compensation of the applicant's right to subdivide in a way which was consistent with zoning law is not consistent, said the court, with the terms or plan or policy of the Act. In other cases, and this is at 209, greater weight is attributed to the role conditions play in protecting the public interest. The logic often manifests itself in judicial adherence to the separation of powers. A court will not intervene to substitute its own view of what is fair and reasonable condition for that of a local government. I'd like to now move on and, if you like, conclude comments in relation to Chapter 6 by dealing with the third part of the chapter, which deals with the matter of charges. Part C, infrastructure charges and conditions, pages 210 to 219. And Bates says that a financial charge for development infrastructure must be levied. Infrastructure is defined at the bottom of the page as including land and works, infrastructure works to ensure that the land is suitable for development. There are two types. There's trunk infrastructure, which is a priority, and non-trunk, which is non-trunk infrastructure, which is not priority. Now, there's some commentary on priority infrastructure plans, which are part of the scheme that identify a local government's plan for supplying trunk infrastructure in a priority infrastructure area. Page 212 talks about the costs and charges for infrastructure, and local governments experience significant urban growth are encouraged to prepare their own infrastructure charges schedule. They use a template number 2 in the guidelines. And over the page on 213, an infrastructure charge notice is not subject to section 345. Applicants may appeal to the court against a charge notice, but only in relation to the actual calculation of the charge. And the question is the charge so unreasonable that no reasonable relevant local government could have imposed it? There's comments then about regulated infrastructure charge schedules, where instead of developing and adopting their own schedule, local governments, particularly those which are not growing quickly, may simply adopt and accept and introduce the template number 1 of the guidelines as their own. Now we talked about trunk infrastructure. There's comments at 214 where the Act recognises that infrastructure will not necessarily be developed in accordance with projections stated in the Priority Infrastructure Plan. And over the page at 215, necessary trunk infrastructure is infrastructure required to service premises where existing trunk infrastructure is not adequate and the PIP identifies a need for that infrastructure. It does not matter that the infrastructure will also service other premises and the applicant will have to pay. But should that be the case, the applicant will not have to pay for the infrastructure charge for the network and is entitled to a refund proportionately. All right, well, I'll just leave you to read the rest of that chapter for yourself. Conditions that state infrastructure providers may impose infrastructure, and that may be done, and they may impose conditions in order to protect the safety or efficiency of the network. Okay, there's a lot of reading, I'm sorry, but I hope that you're making your way through that. And for the moment, I propose to now leave England and move on to Bates. Before I do, any questions?
John, I just got a general question. It's a pretty broad question, I guess. It's just in regards to how to get your head around the hierarchy, I guess, of the various legislations and instruments, etc. How they all, if there was a diagram
Yes.
or just something to bounce off all the reading, just some way to be able to visualise how all these things interact and come together or interplay with each other.
Yeah. Look, I think that's a very fair comment, and I haven't prepared one, but look, I might keep an eye out for that, and if you or any of the other students do come across one, I think we'd all love to share that, so thank you.
Yeah, okay, thanks.
But I don't have one handy, sorry.
That's okay.
Okay. All right, let's now look at Bates, and that's chapter 9, where we deal with environmental assessment of projects. This is pages 295 to 339. And in the introduction, Bates says that governments and local government licensing of projects that are likely to have environmental impacts is the cornerstone of environmental management. And the chapter deals with assessing impacts of development and how this is set out, the ground rules are set out. Now, the first point deals with development control in environmental planning legislation. And at 9.2 at the base, it's generally an offence to carry out development without consent where consent is required. Well, I guess that makes sense. At 9.3, where a local environment plan requires a development consent be consistent with the objectives of the plan, this does not require a positive finding of compatibility. Rather, it's meant not incompatible or inconsistent. Perhaps if I could now move to part 9.5 in Bates, and comment is made under the heading of General Scheme of Development Control. And generally, developments can be classified as permitted, development that does not need consent or exempt, complying, prohibited, or development that needs consent. And in Queensland, all development is exempt unless it falls into a category that requires assessment. And we've really talked about that before in previous chapters in England. Before the development can proceed, applications may be required to be referred to other government agencies for concurrence, either a proposal or for advice, and we talked about that in England. So a lot of this is really covering what we covered in England. But Bates goes on to say that effectively, Other licensing agencies may therefore be able to veto a proposal by refusing to issue a license for aspects of the proposal controlled by them, and that approval authority may also be a concurrence agency, and that's section 93A of the Act. So just because a development does not need planning consent does not mean that environmental assessment will not be relevant. And at 9.9, Bates says, if the proposal is one where the permitting authority does have power to refuse, the authority will generally be required to advertise the application and, after due consideration of any public submissions prompted by the advertisement, make a decision whether to permit the development or refuse it. Now on page 301, Bates goes on to say that apart from any rights granted by legislation, the general proposition is that there are no rights to public notification of a development unless environmental planning instruments extend such rights, although many local authorities do make a practice of giving informal notice to landowners and stakeholders, and that's to ensure that the rules relating to natural justice are adhered to. Failure to give appropriate notice may result in the process being declared legally invalid, and there's that word declared again, and the authority for that proposition is SCUR and Brisbane City Council. That's a 1973 case. Now the second part of this chapter deals with assessing the environmental impacts of development, and at 9.10, in making a decision about an application for development consent, environmental factors are of prime concern. And at 9.11, proposals that are likely to involve significant environmental effects may be required to undergo a formal process of environmental impact assessment. Now, when we look at the Queensland position, we just need to go through to page 313. And in Queensland, this is at 9.31, all development is exempt unless assessable, self-assessable, prohibited, or development requiring compliance assessment. And we talked about that previously. So hopefully those sorts of terms, those concepts are starting to become much more familiar to you. There is now commentary about IDAS. We covered this in England, and there's some commentary there with, once again, the 5 familiar steps for IDAS set out on page 314. There is the assessable development regime, where a regulation may require impact or code assessment, or both impact and code assessment. Code assessment means assessment of development by the assessment manager against the relevant state regulatory provisions, plans, schemes, and other planning instruments. So again, we talked about that previously. Now, this I'll go through now to talk about planning agreements, which is on page 324. And that's on paragraph 9.47. A planning agreement is a voluntary agreement concluded between a developer and consent authority, under which the developer may agree to provide material public benefits or pay monetary contributions for public purposes, or otherwise achieve or advance the purposes of the planning regime. Okay, so we talked before about planning partnerships, and this is really a planning agreement, which is a voluntary situation. Some interesting comments about fast-tracking major projects, which is on page 326. And at 9.52, Fast Track is a legislative device to provide a streamlined approval process for developments of particular economic or other significance for the state. And at 9.53, in Queensland, under the State Development and Public Works Organisation Act of 1971, significant development may be fast-tracked by having all relevant permit applications referred to the Coordinator General for Environmental Coordination. And the government's assessment of the importance of tourism industry also led to the passage of the Integrated Resort Development Act 1987 to provide for accelerated government approvals of large-scale private tourist development proposals. I won't go into the politics of what was happening in 1987, but I'll leave you to look at that and think about that. 9.60 in Queensland, in addition to the powers conferred upon the Coordinator General, which we talked about before, the Minister may give directions to assessment managers about matters of state interest. We talked about that when we were looking at England, or call in a development that affects a state interest. You remember we talked about that before as well, so that the Minister becomes the consent authority. And previously we talked about how the Minister's call-in powers and directions might be attacked and have been attacked in court proceedings and on some occasions overturned. At 9.64, there's commentary in relation to special development legislation. And another way for governments to facilitate major development projects is to persuade Parliament to enact special legislation for those projects. And many long-term developments have been authorised by that way. And then there's talk about indenture or franchise agreements, where Bates says that such techniques are generally used to support multi-$100 million minerals recovery and processing projects. And there's talk there about Mount Isa Mines situation. All right, well, you've been very patient in listening to me prattle on. I hope you've been able to keep at it. I guess if you're still listening, you have, so congratulations. I'll leave you with this. It's to do with appeals. It's in Bates, it's page 333. And applicants for development consent or objectors to development applications are often allowed to appeal the decisions of planning authority to specialised courts or tribunals. So we know that. Since there are merits appeals, the decision of the appeal body on the merits is final, though points of law arising from such an appeal may be appealed to a court of law. And a merits appeal is where the court or the tribunal steps into the shoes of the executive making the decision and effectively makes the decision for the executive. Or alternatively, on hearing the case, can confirm that the decision made by the executive was correct, or can refer the decision back to the executive to be reconsidered based on certain directions. Significant examples of merits appeals are reported in publications such as the Queensland Environment and Planning Reports. All right, well, that then brings us to the end of what is really the content for week 4, even though we're in week 5. I won't go any further. The reading that was allocated for week 5 can carry over. There'll be further reading, and I'm very aware that I'm now a week behind. And I do hope that you enjoyed listening to Roger Curry, who's, I thought, a very interesting speaker as last week's special speaker. And with luck, I'll have another 1 or 2 special guests coming on throughout the program. So unless there's any questions, I'll bring the matter to an end at this stage.
Not from me. Thanks, John.
Thank you. All right, well, I'll stop recording.